The DUI process normally starts in a very simple way. You're pulled over by a police officer. The officer then approaches your vehicle and asks you for your license and registration.
An officer can stop someone for DUI for several reasons. You could be speeding. You could be weaving. Individuals may have been involved in an accident. In addition, improper change of lane. Those are the most common reasons that individuals are stopped and ultimately charged for DUI.
Whenever someone's pulled over by the police, they experience a great deal of nervousness. You may be acting guilty when in fact you're totally innocent. The officer will take those reactions and your nervousness as someone who's hiding something potentially, when it's just a nervous reaction when confronted by the police. Everybody experiences it.
In the state of Florida, after you're stopped for DUI and an officer observes what he believes or she believes to be signs of impairment, they will then ask you to submit the field sobriety test.
One of the first ones that they usually ask you to do is the walk and turn, which is where you take 9 heel-to-toe steps down the line, make a small pivot, and take 9 heel-to-toe steps back. After that walk and turn, they'll be asked to do the one-leg stand, which is where you hold your foot up for 30 seconds while looking at your toe and counting out loud. The officer may make a decision at that point as to whether you're under the influence of alcohol. If he is not sure at that point, he will ask you to do 2 supplementary tests. One is the finger to nose, and the other one is the alphabet test.
Field sobriety tests are not scientific evidence. They're tests that are not done on a normal everyday person, unless they work in the circus. Whether or not those tests are accurate is for the jury to ultimately determine.
They're testing you on things that you've never done before, you've never had the chance to practice, yet they're using those tests to make a decision as to whether your liberty is going to be lost. Once you've finished performing the field sobriety test, the officers will make a decision at that point whether to arrest you for DUI. At that point, you're transported back to a jail where you're offered the opportunity to take a breath test. The breath test in the state of Florida is required by law, or else you'll lose your privilege to drive.
Over the years, Florida DUI law has gotten much harsher. Individuals who have refused to take a breath test on the second occasion are now charged with another crime. It's called refusal to submit to a breath test.
In order to effectively cross-examine and challenge that machine, we must know the inner workings of it. Along with David, who used to be in the state attorney's office and was the former DUI prosecutor of the year, his experience has helped our firm understand that machine.
The Florida Department of Law Enforcement has written rules with regards to breath testing. Those rules must be complied with in order for you to be found guilty beyond a reasonable doubt. If you go in and plead to the case without representation by attorney, you will never know whether or not you had a valid legal defense to your charge.
After you're released from jail on your DUI, this is the time where we need to get involved. Things happen in a case early on that we need to be there for. We need to request 911 tapes. We need to maybe request receipts from the bar or the restaurant that you were at. This is a time where it is extremely important that you get in touch with legal counsel.
A DUI can be looked at like a tree with 2 branches. The branch on the left is the driver's license side. The branch on the right is the criminal side. First and foremost, we need to do everything we can to obtain a temporary permit for our clients so that they can continue to drive. They can drive to work, to school, to church, to synagogue, anything to maintain their livelihood. The criminal side is something that comes in the future, usually about 20 to 30 days from the date of the arrest.
Your case can go one of 2 ways. One, it'll be negotiated with a plea settlement, or it'll be set for trial. Either way, nothing will happen without your permission or without you being there and advising us what you would like to do about your case. If the case is set for trial, at that point, we need to get ready, and we need to do everything we can to make sure we're prepared to deal with what the police officer is going to testify to and what the state attorney is going to offer in evidence in your case.
We can't stress to you enough how you need to call the firm for a free consultation. You can always call toll-free at 1-800-FIGHT-IT. You can get one of the attorneys on the line, and we will do everything we can to go over the facts of your case.
There's nothing more rewarding than getting a great result for a client. When they first come in that door, they're scared. They're worried, what's going to happen? When you end up beating that case or getting a not guilty after a jury verdict, there is no better feeling in the world. And that's what makes us fight each and every day for our clients.